to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's topic is antitrust due for an overhaul? Learnings and lessons from the 1970s. In an earlier episode, we discussed what has been referred to as the quote-unquote new Brandeis School of Antitrust, which of course implies that there was an original Brandeis School of Antitrust. Today, we are joined by a storied practitioner who lived the change from the 1970s to what is now referred to as the Consumer Welfare Standard for evaluating effects on competition. Recent calls to overhaul the Consumer Welfare Standard, or to at least expand its scope, beg the question of why we moved away from the Brandeis School in the first place, and what lessons can be learned from that experience. Joining me today is my co-host, John Roberti. Hey, John.
Christine, how are you?
I'm well. How are you?
I'm doing just fine.
So, John, tell me, what are we talking about today?
Christina, today we are going to try to, once again, get some perspective on some of the things we're hearing about that a new approach to antitrust. We think we might have been through this sort of analysis before. And what we'd like to try to do today is learn from a guest who lived it the last time and try to understand a little bit about these changes, this new Brandeis antitrust approach that you were talking about, how these changes, what we can expect and what lessons we maybe can learn from the last time that we saw changes like this, which was probably the 1970s.
Who's our guest today?
Christina, our guest today is Tim Muris. Now, Tim is well known to the antitrust community. He has a long history of service, both public service and service in academia. He is a professor at the Scalia Law School at George Mason University. He's also senior counsel at Sidley Austin. And he was the chairman of the Federal Trade Commission way back in time when I actually worked there. Absolutely delighted to have him.
Great. Welcome, Tim.
Great.
So,
thank you.
So Tim, let's start with some basics. What are you seeing today in terms of a new approach to antitrust that may look familiar to you?
Well, maybe a couple of sentences of background would help. I came in, I was 23 years old in 1973 when I was offered a job to go to Washington with a professor of mine to the FTC. And it was a time in consumer protection, the views of Ralph Nader, and for that you can read Elizabeth Warren, were becoming predominant. In competition, there was a marriage, uneasy in some ways, between populists who very much like the neo-Brandesians and industrial organization economists who agreed, although for somewhat different reasons, that big is bad. There was something called the simple market concentration doctrine, which had a much different view of concentration than we've had in the last 40 years. For example, the marginal merger was an 8-7 merger, and the courts were much more receptive to challenges of mergers and everything else. For example, in the first half of the 1970s, the FTC's record on appellate cases was 21-2. The Congress was very encouraging. It was coming out of the 60s. There were two reports, one by the whole ABA, not just the antitrust section, that encouraged the FTC to be aggressive. And that led to a lot of what I'm sure we'll talk about. But it was, the FTC was being pushed out of what was regarded as a very tired period of the 50s and 60s.
And we see some of that. We see some of that today. I mean, you mentioned Elizabeth Warren, but we see some of the same sort of populist views of antitrust even today. Is that what you're seeing as well?
Yes. If you look, there's some startling similarities. For example, some of the rhetoric is quite similar. The chairman of the FTC in the mid '70s said, and this is a quote, he said, "No responsive competition policy can neglect the social and environmental harms produced as unwelcome byproducts of the marketplace. Resource depletion, energy waste, environmental contamination, worker alienation, the psychological and social consequences of marketing stimulated demands." And they were trying to figure out how to work this into Section 5. But very recently, the Biden-Sanders task force released this 125-page statement, and it had a little bit on antitrust law in it, and they said that mergers should look at not just the effect on prices and the effect on concentration, but also on things like what happens to labor markets and what happens to racial discrimination. So the similarity between, let's go beyond economic analysis, is there. And there's also, it's striking. One of the things that's striking is the House is looking at the House Judiciary Committee. They had the hearings last month with the big tech CEOs, and Lena Khan, who's a professor who wrote a very famous article. That article is attacking Amazon is really a throwback to attacks on the Great Atlantic and Pacific Tea Company, and you can really substitute the two for each other. And the populist attacks of even days before the 70s, but that continued into the 70s have come back again in very similar terms.
It's really remarkable because, and so often we see this happening in antitrust, where what we thought was the technology of the time, 30 years later, seems passé. But many of the concerns that are being expressed today are things we've heard before in many of the cycles as well. Tim, what was the reaction? You arrived in Washington in the 1970s at the FTC, and you sort of saw this firsthand. What was the reaction to this, to the sentiment that was coming forward then?
Well, the reaction was a very aggressive FTC, both in antitrust and consumer protection, and to some extent, a significant extent, this spilled over into the Justice Department. On the antitrust side, the FTC launched a very resource-intensive deconcentration effort. They brought what was a shared monopoly case against the cereal industry. Shared monopoly is the idea that the leading firms in the industry were sharing the monopoly. Not one of them didn't have the monopoly. In 1973, the commission brought a case to vertically dismember the oil industry, which wasn't particularly complicated, but it was following everything that happened in that decade. This actually preceded most of it in that decade with the Arab oil boycott and the increase in gas prices. But there had been 45 votes in the Senate to break up the oil industry, and the FTC filed a suit, which actually became known internally later in the decade as the FTC's Vietnam, in the sense that it was years before they could even file a coherent statement about what the case meant, and there were just dozens and dozens of FTC employees rotated in and out of that case. Then in in 1975, the FTC began what was the dream of all industrial organization economists, a massive investigation to break up the auto industry. And that was very strange. I was born in Stark County in Ohio, where the Pro Football Hall of Fame is. My dad, who's long dead, actually played on the first team. Paul Brown coached at Massillon Washington High School. But we moved to Southern California, to San Diego, when I was in seventh grade. And so I had grown up where 40% of the cars were foreign. And my first car was a Volkswagen Beetle in college. And when I was a young attorney in the Office of Policy Planning at the FTC, I drove a Toyota Corolla. And this memo said, and 40% of the cars in California were foreign, the memo said, foreign cars are irrelevant in the United States. Well, I thought that was interesting. And it said, we already have enough evidence to break up GM and probably Ford. And so they launched this massive investigation, took incredible amount of resources, and they closed it several years later. And Rich Rosen, who was involved, said, we couldn't find any monopoly profits, monopoly losses maybe, but no monopoly profits.
And this idea is interesting because, again, a lot of what you're hearing today is break up this company or that company, and again, and with an industry that is ubiquitous like the auto industry. So again, I guess sounds like we're hearing echoes of the 1970s even today.
Yes, yes, that's right, John. That's obviously an excellent point. Is that the crusade against bigness has returned, and it's to the leading consumer goods firms. The leading consumer goods firms are not the what you go to the grocery store to get, but they're the big tech firms. And I personally believe that the antitrust laws are capable of dealing with the tech firms. It certainly looks like, if you believe the papers, that the Justice Department and the FTC are about to bring cases against the big tech firms. I find it, incidentally, parenthetically, one of the shocking developments to me in antitrust law in the 21st century, and it's a data point that I suppose helps the people who want change, is that the Justice Department in this century has abandoned bringing single firm cases, single firm monopoly cases. The last, except for one small consent, the last single firm monopoly case the Justice Department they filed two in 1999. I just find that stunning. The FTC, in the meantime, has filed quite many. When I was chairman, we did 4 in 3 years. And the FTC, I believe, in this century has filed a low double-digit number of such cases. But in the 70s, there were an extreme number. Not only that. In 2 other areas, the commission was out of step with what the law, and so was the Justice Department, with what the law became. In the vertical area, there were a very large number of cases attacking both price and non-price restraints. Indeed, the Justice Department, in the end of the decade, said, we're going to criminalize resale price maintenance. There were also significant predatory pricing cases. When one of my coming of age events, the first time I spoke at the commission table, there were 200 people in room 432, John, which, as you can imagine, is a very large number for a commission meeting, and they were there to watch us fight over a case which the commission eventually filed after 4 meetings, where the theory of the case was that General Foods, which was the largest coffee roaster, they were called, in the eastern United States, was trying to drive out a new entrant. The new entrant happened to be Procter & Gamble, which was then the most feared marketer of consumer goods in the world. And they were engaged in this massive predatory pricing war, which started in Cleveland and Pittsburgh and spread all over the East. The Bureau of Economics supported the case with the astonishing remedy of mandatory trademark licensing of the General Foods trademark, which meant that they would have, you would have had several General Foods coffees or Maxwell House coffees, which would have created a tremendous disincentive to maintain quality. It was, in a term of art, it was nuts. And the commission rejected the remedy, but it supported the case after 4 meetings, and the commission eventually in the 80s disagreed with the case after the Part 3 process. But that was one of 3 major predatory pricing cases that the commission pursued in the 70s, and a return to bringing predatory pricing cases and vertical cases is on the agenda of what you're calling the neo-Brandeisians and some of the progressive economists.
It's interesting because, Tim, you spoke about how there haven't really been a lot of vertical cases since the dawn of the new millennium. Not a lot of new single firm unilateral conduct cases since the dawn of the new millennium. I think the same could be said. Yeah, and I think the same could be said of vertical cases, and certainly the same could be said of predatory pricing cases. I mean, predatory pricing, I think the Supreme Court made it very difficult to bring predatory pricing cases with some, with the Brook Group decision, but vertical cases as well. I mean, there was a vertical merger, I think, that was looked at. There have been a couple of vertical mergers that have been looked at, but no vertical conduct, not a lot of vertical conduct cases in this new century. Why do you think that is? Well,
on predatory pricing, there's a misconception that a lot of what's going on here is because of Robert Bork and the Chicago School. On predatory pricing, far and away, the heroes or the culprits, depending on your point of view, are people from Harvard named Phil Arita and Stephen Breyer. The Arita Turner 1975 article on predatory pricing is one of the most influential articles ever written, and it essentially became the law. Breyer was a professor with Phil Arita and Don Turner, and Breyer, until very recently, has voted almost always for antitrust defendants and has been the most influential antitrust justice in the last 25 years. Indeed, when he was up to be on the Supreme Court, Ralph Nader and Lloyd Constantine opposed him as a Supreme Court justice because of his antitrust views.
So, Tim, what do you think? I mean, we've seen fewer of these cases? Are we getting it right? Does there need to be more enforcement? Does there need to be more enforcement in this space, or do we more or less have it right in terms of? And let's focus on the 3 categories you've talked about: predatory pricing, vertical, and single firm conduct.
Well, I think on single firm conduct, I personally am, as I said, I'm very surprised that the Justice Department has abandoned the field. And I believe that the agenda that we had was an appropriate agenda. If you look at Part 3, the history of Part 3 in the last 40 years, there are 2 spikes in FTC activity. One when I was bureau director, and one when Joe Simons and I were there when I was chairman. But the agenda we had was built around professions, healthcare. And in single firm cases, we were particularly interested in people who were misusing the government. We were trying to whittle back the state action and Norr Pennington doctrines. And we were also trying to use misuses of intellectual property. And we didn't win all the cases, but we won the vast majority of cases. I suppose if you actually win every case, that probably means you're too cautious. Although in the 70s, or in the 80s, we actually did win every case. But I think in single firm, I do think there are more appropriate cases than people have been bringing, but I do not think deconcentrating all of the big tech as a lot of the House committee seems to favor, and as the neo-Brandeisians seem to favor, is a good idea.
And Tim, yeah, and I'll just say, when I was a staff attorney working for you many years ago, when you were the chairman, I actually worked on two Part 3 matters, including one of them that involved, the Norr-Pennington Doctrine and intellectual property rights as well. So, what you're saying is certainly true.
Sorry, for the benefit of our listenership, can folks explain to us what Part 3 is and how that how that varies in the regulatory scheme and then also private litigation?
Sure. The Part 3 just refers to the formal litigation procedure of the formal administrative litigation procedure of the FTC. I supported the Qualcomm case, for example, but I thought, and unfortunately, it really looks true, was a major mistake to file the case in federal court. What's the point of having an an independent regulatory agency, if you're not going to bring cutting-edge cases administratively? I think that the FTC outthought itself by going to the Ninth Circuit, and I'm afraid what's happened in the Ninth Circuit is it's sort of a Newton's law. Judge Coe wrote an unnecessarily aggressive opinion, and that produced an unnecessarily restrictive opinion out of the circuit court. Where what should have happened is it should have stayed in the administrative process. And I do believe that Chairman Simons would have been unrecused and able to participate. And Joe's a superb antitrust lawyer, and the commission would have been able to produce a much more thoughtful opinion, allowing for more appropriate circuit court review.
Yeah, Tim, and Part 3, as I recall, is it's an administrative procedure within the FTC, so that the case originally goes to an administrative law judge who takes in the record, gathers the facts, often will write a preliminary opinion. That preliminary opinion is then assessed by the full commission, which in turn writes its own opinion. It can make its own findings of facts, of course, but generally taking the record that was created by the administrative law judge and turning it into an opinion. And those opinions that are written by the commission ultimately get appealed to a circuit court, but they become very persuasive documents and vehicles for the commission to describe, for commissioners to describe their view of the state of the law. So it is a powerful tool, and as you said, one that you use frequently.
Yeah, that's correct. And one of the things, John, you worked on the Three Tenors case, as I recall, right?
That's exactly right, and the Unical case.
Right, both of those. And in the Three Tenors case, the view of so-called truncated rule of reason analysis has been blessed by multiple circuits, and that's very important. In Unical, the commission wrote under my name, a good opinion on Norr-Pennington analysis. It did not get appealed for complicated reasons. Unical was purchased, and then the case settled. But still, those, as John is saying, those opinions can be influential and important. And I think, for whatever reasons, the Obama Commission made less use of the Part 3 process than it should, and they even in cases that were cutting edge, like Qualcomm, and their first non-cash pay for delay case, which, if any case should ever go to Part 3, I would thought it would have been that case. They did not use Part 3. And
by the way, that was a case where Breyer actually did vote with the defendants. I happen to have represented one of the defendants in that case. After my time at the commission. So Tim, this has been a really very interesting discussion, and I think what we've learned is there was a view in the 1970s that was a very aggressive pro-enforcement view. As you've talked about a bit, it's that view led to some cases that were probably were ill-advised, and there was a reaction to it, and the reaction was to pull back. What do you think are some of the lessons? Okay, but you now have a group that's saying we want to do more enforcement. What are some of the lessons learned, and what advice would you give to these folks that say they want to do more enforcement?
Well, some of them, some of them have asked me. I'm lucky to be blessed with good genes. Everyone in the family says I take after my maternal grandfather, who lived well into his 90s, and I'm hoping to remain active for another 25 years or so myself. And so I'm paying obviously close attention to these issues as I've just turned 70. The first thing on the substance, I would obviously pay attention to the economists, and although there are economists who support more aggressive antitrust, they, I think, can be a check on some of the more extreme and aggressive views of the neo-Brandeisians. Economic matters. The economists matter, but you also need workable rules, and that's where the Harvard people and Phil Labrita were so important. And the defense. I've got an article coming out on predatory pricing, and the main defense of what they did. You can come up with theoretical cases, going back to the 1930s and limit pricing arguments, where the Rita-Turner test doesn't capture. But you need rules that judges can enforce, and that's true throughout antitrust. In terms of the procedures, here's where there was real problems in the 1970s. My good friend and former FTC chairman Bill Kobasic likes to make this point. He said that an agency can only take so many kind of bet the ranch, bet the agency initiatives, and the FTC had something like 15 or 20. We haven't even talked about in the Bureau of Consumer Protection. The Bureau of Consumer Protection went through one 15-month period where they issued 16 major rules. And these were rules to transform entire industries. This is very much, again, in the Ralph Nader, Elizabeth Warren view of the world, where the market doesn't work, so we need to come in and change the way it works. If you try to do that across the economy, you're asking for trouble. So I think you need to limit your appetite. Second, and this is directly related to the first, is you need to think of your remedies up front. One of the problems that they had was, they saw these problems and they just, they started these big rulemakings and cases, for that matter, without thinking of where they wanted to end up, and that was a problem. Third, you need to manage the cases and the people better than they did. Now, part of the problem was in the 70s, and I hear people talking about this again. In the 70s, they decided to throw money at the problem, and the size of the agencies increased faster than people could control. So you had cases with no real supervision, and you actually had little fiefdoms where individual people became powerful in the agencies. When I came in as director of the Bureau of Consumer Protection, I was 31 in 1981, and we reorganized an organizational structure that still sticks. We abolished some jobs and we did a lot of things to try to deal with these managerial problems. A fourth thing is, even if they become rule happy, and I think even in competition they're talking about doing that. I would urge them to keep a focus on litigation because litigation can be done more quickly and in some ways more effectively. So those are some of the I think the major lessons. I mean, I don't support the revolution to come, but it may well come. But those are ways I think it could be done more effectively.
All right, Tim, and this is my last question before I turn you back to Christina. But what's your prediction? Are we going to learn the lessons of the past, or are we doomed to repeat them?
Mark Twain says that history doesn't repeat itself, but it rhymes, and it certainly appears to be at least rhyming. I have all these boxes from the 70s in my basement that have come out of the basement that I used to think were only of historical relevance, and now are directly relevant. I hope people don't repeat the mistakes, but they really seem. It's just astonishing to me how much so far people seem to be marching, very much on the same path. A lot of what happens will depend on the what happens in the elections to the Senate, because if the Senate, if the Democrats sweep the whole field, then most political observers, I'm not an expert on this, believe that the filibuster will fall. If the filibuster will fall, then there will be budgetary and legislative pushes behind the new. Behind the revolution, and that could make a significant difference. Now, of course, the judiciary is different than the judiciary was in the early 70s. The judiciary now, although the judiciary in the late 70s became a major problem for the agency, the FTC had an astonishingly bad record of cases that it brought in the late 70s. They, believe it or not, like their record in mergers in the cases they brought in the late 70s was 8 wins and 14 losses. That's bad. But there's a lot of talk if the sweep occurs that we'll just create a lot more judges. So I think the problems that I listed, people believe they can overcome them just by more money, more people, and changing the law and changing the judges. I hope all that doesn't come to pass.
Great, Tim. Well, thank you. This was a very interesting discussion, and I love that Mark Twain quote, very apt for this episode. And I expect we could all spend many more hours arguing and discussing the merits of these proposed changes, but no question that there are many lessons to learn from the past, both substantively and procedurally. So it was great to hear from you on that. Before we go, we always like to ask each of our guests a couple of questions. The first is to tell us something interesting about yourself that we wouldn't know about you if we just knew you professionally.
Well, in my offices, and I'm not in much. I mostly work remotely in any event. I have John probably remembers some of this is in the chairman's office when I was at the FTC. I have pictures from various baseball teams in a rain delay during in 2000, which is last year I coached. I had two sons. I have two sons who were 6 years apart, and during that rain delay, I calculated I'd coached 500 youth baseball games. I often, there's many things I do that I don't do sort of halfway, and it was an enjoyable experience. Although there are many things about teenage boys that Phil Graham once said it was the way teenage boys are the way they are because it's God's plan, so you can let them go. So,
Tim, was your record as a youth coach more like the FTC's record in court in the 70s or the FTC's record in court in the 80s?
Our record was very successful, but there were two kinds of teams. They were all successful, but there were all-star teams in which, I paid a lot of attention to the record, and we did, we did extremely well throughout. But in the regular teams, although we were normally very successful, what I found is that the kids, it was important to the kids, not to get hammered, but it wasn't all that important to them whether they were, whether they won the league or anything. Although we often did, they wanted to learn and they wanted to be competitive. And I enjoyed the teaching part of the, putting a team together. And I loved to teach hitting. I ended up owning an indoor batting cage. I had a little sports field in one of my houses with a batting cage on it. And I ended up buying an L screen because as the kids got older, an L screen is something when you see batting practice that the batting practice pitcher hides behind. I had to get closer and closer to as my boys became, teenagers. I'd get closer and closer to throw hard enough. So I got an L screen that I could hide behind. It was a good experience. And actually my two sons were not, I saw many of their teammates treat their parents very shabbily, and that was not a problem for me.
Well, I'm sure you had years and years of giving very good baseball advice and many, many years giving good legal advice to, I'm sure many who attribute you as a mentor during their career. We do like to ask all our guests what advice you would have for students or younger lawyers looking to do what you do or what you did. It's a loaded question, but I'll leave it there.
Sure. Well, I've had a very fortunate career and had a lot of great opportunities. I've had 6 jobs in the federal government, 4 at the FTC. Been lucky enough to have been not just chairman, but the only person ever to have been both bureau directors. So I've been very blessed. But I advise people to distinguish between goals. You want to get this job, or you want to do this in your life, and purpose. And the purpose, in my case, I decided, believe it or not, at age 17, I had an opportunity pointing my life in one direction, decided not to take it because I decided that I didn't even call it that I wanted to get involved in public policy. Then I didn't know that was what it was called, but that's what I decided to do at age 17, which is a pretty young age to do that. I graduated from high school at age 17. And that's what I've done my whole life, and have been very lucky at doing it. The 2 of those 6 jobs were in the White House complex. I've worked on several campaigns and transitions. And the other more practical advice that I give to people is I tell them that sleep is a weapon and to get some sleep. I used to sleep more during finals, for example, than I did normally.
Great advice. Well, thank you, Tim. It's always good to hear from our guests a little bit more personally. And before we let you go, just our final segment called The Curious Hat.
And now it's time for The Curious Hat.
So, Tim, in normal circumstances, we would have a physical hat, and you would pick out a number 1 to 25 out of that hat and answer the question on that piece of paper. In present times, we're just going to ask you to pick a number 1 through 25.
Okay. Well, I was born on the 18th, so why don't we pick 18?
Okay. I think this is perfect for you. What is an accomplishment you are most proud of?
What is an accomplishment I am most proud of? Well, I've got lots of personal accomplishments, like raising my two sons alone. But let me stick with professional. I guess I'm most proud of having stuck to a career where I tried to live according to that purpose that I decided on when I was age 17. So
I was going to vote for the opinion you wrote in the Three Tenors case because I thought that was quite an accomplishment.
Look, I've had. If you look at individual things on the thing by 15 minutes of fame in life was the do not call registry at the time, and of course now the irony is I ask my students every year. I ask them lots of things, but I ask them, how many of you read a newspaper the old-fashioned way, and how many of them have a landline? And increasingly, it's the answer is 0 to both. So that accomplishment with do not call is become irrelevant, and of course robocalls have become the scourge, and robocalls will be solved by the same way spam was solved by technology, and in fact there are starting to be some decent spam filters. I have one on my phone that's not bad.
And Tim, you mentioned, you mentioned, hoping to have, 20, 25 plus years left in you. Something on your bucket list that you'd like to achieve?
Well, I actually, that gets on the goals list. There are some there are some goals professionally that I haven't achieved. I would certainly like to have influence on the directions of certain aspects of public policy and the economy. In a market-oriented way, but the world would have to turn back in a way that it is turned away from for that to happen, and that would be nice.
Well, 2 decades is a long time, so time will tell.
Yeah, Tim, and listen, as an FTC geek and somebody who has been chairman of both bureaus, director of both bureaus plus the chairman. That's all. I think you probably have hit for the cycle on the FTC. I don't know if you want to go back and be a staff attorney or something, just fill it out. But from the perspective of the FTC fans,
this job was like that. But when I was a kid, look, working in the government is great, and the people at the FTC are great. And although I'm unlikely to go back to the government. So. But I've enjoyed this, and I'm a big fan of the podcast. So.
Well, thank you, Tim. We enjoyed having you. Thank you for joining as a guest, and thanks all for listening in to this episode of Our Curious Amalgam. We'll see you next time.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.